So having said that, it's time to commence the panel 3, Maritime Law Enforcement. Next, please. I am very honored to introduce 3 distinguished speakers. So please come up to the desk, please, front desk, please. Okay, so this panel is moderated by Mr. Shanaka Jayasekara, UNODC, with 3 speakers. I will introduce him after in the panel 4. So now I move to the first panelist, Dr. Robert McLaughlin. Yes. From Australian National University. His presentation is Maritime Autonomous Vehicles and Drug Trafficking by Sea, Some Legal Issues. He will speak about MAV, I said the Maritime Autonomous Vehicle, used in MLE in the view of international law. And we had a pre-recorded session. The second panelist is Lieutenant Commander Jean-Pierre Spence from United States Coast Guard. Pierre, the title is Unmanned Craft and Maritime Law Enforcement. He will speak about U.S. Coast Guard policy developments and challenges faced by USCG and their plan for the future. The third panelist is attorney at law, the Miyoshi Toshiyuki, Sato Takemune Law Firm. Title is Criminal Liability in Autonomous Navigation. He will speak about mass from the view of domestic law, I mean the Criminal Act. So, Mr. Shanaka, floor is yours.
Good morning, everybody. As I've introduced, my name is Shanaka Jayasekara. I'm from the United Nations Office on Drugs and Crime, Global Maritime Crime Program. I have been co-opted in to moderate this session as Dr. Rob McLaughlin is unable to attend. So I'll do my best to try and moderate this session. As Rob was unable to come to London, we did a recorded session a few days ago. So the recorded session will be played now as the first panelist. Thank you.
Welcome to the presentation by Rob McLaughlin. This will be a recorded presentation, and it's an honor for me to introduce Rob, who in fact was my first boss as I joined UNODC back in 2013. So it's a dear pleasure to have Rob here. Rob is an honorary professor at the Australian National University in Canberra and an eminent expert in international maritime law. Rob will be speaking to us on maritime autonomous vessels and drug trafficking by sea, and he'll be looking at some of the legal issues relating to this subject. Rob has exemplary career both in academia and also as a practitioner, having served in the Royal Australian Navy and also with UNODC in the past. Without further ado, let me Rob to make the presentation. Over to you, Rob.
Thank you very much, Shanaka, for that very kind invitation. It's wonderful to see you again. And can I just say it's a great pleasure to be able to participate in this conference. And thank you very much for to the team for the opportunity. I'm really very sorry I could not be there in person with you all, but I can reassure you that it's much warmer here than it will be for you all there. So as Shanaka said, I'm going to talk a bit about maritime autonomous vehicles and drug trafficking by sea. Next slide, please. What I'll talk briefly about is the issue of whether maritime autonomous vehicles or MAV are ships or not. Then a little bit of context about maritime law enforcement use of MAVs and criminal use of MAVs, in particular in drug trafficking at sea, but not only in drug trafficking at sea. Then look at some legal issues with law enforcement, maritime law enforcement on one hand, and used in crimes at sea on the other. And then some brief concluding thoughts. Next slide, please. Next slide, please. So the first question we always have to face, and all of you will be aware of this and know a great deal about this, is, of course, whether the MAV is a ship. In broad terms, an MAV is a vehicle vessel that operates on, below, or above the ocean's surface with varying degrees of human control, but we're really concerned with those MAVs that don't have any humans or controlling humans on the vessel or vehicle itself. I'm really going to focus only on and below the sea, aerial MAVs being a slightly different category of issue. So one of the issues we have to face immediately is, how do we classify any particular MAV that is operating on or below the sea? Of course, we're thinking of vessels, and that's particularly the focus of this presentation. But if it's not a vessel, it might be the system of some other parent vessel, or it could be just a non-vessel asset. And the picture there is obviously of the glider that was taken up by a Chinese vessel, US glider. And of course, you know, that's about 2 meters long. So is it categorized as a vessel, or is it categorized as a system, an independent system linked to some other vessel, even remotely, or is it just a non-vessel asset? The complications here are there's, of course, no single definition of vessel, and the Law of the Sea Convention 982 has no definition of vessel, as is well known. Many of the definitions of vessel are very purpose specific, and they often link to other factors such as sovereign immunity. We'll look at warship in a minute as an example of that. So there's really no set list of factors that determine the issue of whether a particular MAV is a vessel or a non-vessel, something else. Size is not the answer. The purpose it's put to is not the answer. Registrability, can it be registered by a flag state? That may be an issue. And of course, national laws vary considerably. Next slide, please. To me, the best start point is the collision regulations, or the rule of the road, which has a really good definition, general definition of a vessel, and you can see it there, all watercraft used or capable of being used as a means of transportation on water. This is really the starting point, I think, that we ought to start from. But other factors, such as the purpose of the vessel, how and who is operating the vessel, can overlay this definition to make the vessel not a vessel in certain situations. And a warship is a classic example because of the extra elements in the definition of warship, such as commanded by an officer, crewed by a crew under military discipline, and so on. Next slide, please. State practice is still emerging in this area. There's very little published state practice on whether warships can be maritime autonomous vehicles or vessels. Certainly the US has recently, in its recent update of the Naval Commander's Handbook, made a clear statement that it does believe this is the case. And in the UK, of course, this has been considered, and there's a likelihood, I think, that the UK will tend this way. I think inevitably the law will follow practice here in terms of MAVs being capable of being described as warships. So the key issue here, of course, is that MAVs are one type of vessel. It might meet the coal rigs definition, but whether it can then go on and have the rights and obligations of another specific type of vessel like a warship really depends on that specific purpose-driven definition that applies to that subcategory of vessel. Next slide, please. And I'd just note that a very eminent scholar, Wolf-Heinrich von Heinig, has, in the context of Ukraine and the Ukraine use of MAVs in the current war against Russia, really thinks that we've moved past the debate now, and we're almost at the point where it needs to be accepted that MAVs can be warships. Next slide, please. So how are MAVs used in maritime law enforcement? Well, the current key use is intelligence, surveillance, and reconnaissance. Obviously, they can be used to surveil internal waters, territorial sea, contiguous zones. They have clear utility in surveilling EEZs and doing fisheries intelligence, surveillance, and reconnaissance. There's an emerging use of MAVs for continental shelf monitoring, for example, checking undersea data cable security. And there's an emerging use of marine data collection that assists maritime law enforcement purposes. Next slide, please. In contrast, how are MAVs used in the criminal context? Well, there are many possible uses. MAVs can be used as a vessel-borne improvised explosive device or a weapon. Ukraine, we've seen this happening, and one should possibly keep an eye on how the Red Sea shipping attacks are developing. There is every chance that MAVs might start to be used for shipping harassment in the Red Sea. MAVs can be used to transport illicit cargoes. They can engage in transshipment, the landing of cargoes such as weapons, drugs, which we'll talk about in a minute. You can see this article here about the potential for small vessels to traffic nuclear material and the need for autonomous radiation detection, for example. Illicit oil and fuel, particularly in breach of sanctions that might be over particular countries or particular cargoes. MAVs can be used in all of those sorts of illicit traffic processes. People are a challenge because MAVs might be used to smuggle people, trafficking people or smuggling of migrants. And this really challenges the no people on board assumption that tends to follow MAVs, and that has real implications for how we might think about use of force in relation to MAVs being used for criminal purposes. Next slide, please. So what are some legal issues with MAVs when used in maritime law enforcement roles? I'll just talk about 4 quick issues. The first is, well, what are the implications of the whole question around whether an MAV is a ship or a non-vessel system? For example, in the Law of the Sea Convention, there are many articles, one example being in the article on hot pursuit, Article 111, which talk about certain rights of maritime law enforcement vessels only being able to be exercised by warships or other ships clearly marked and identifiable as being on government service and authorised to that effect. So this is an additional impost on the qualification of an MAV to actually exercise maritime law enforcement powers or be part of that nexus. It must also, therefore, meet these additional qualifications required under the Law of the Sea Convention and hot pursuit article, for example. It's also interesting to look at different national law and to work out in any particular given national law who is actually or what is actually the empowered agent for maritime law enforcement. Is it the status of the vessel upon which agents, physical persons are located, or is it the people themselves that carry the authority? If it is only people, then this raises issues around whether the MAV has to meet all of these requirements. Unresolved regulatory issues are well known, and the International Maritime Organization is certainly deeply engaged in inquiring into the gaps and lacunae that may exist in this area. The sheer variety of purpose-specific definitions, which we've talked about, does challenge whether MAVs, which might meet the COLREG's definition, can actually be vessels for the particular purposes that we might be considering under different instruments. There's also quite a wide variety of regulatory regimes over things like crew levels, watchkeeping, rescue obligations, the carriage of safety of life at sea equipment, for example, cargo damage responsibilities, salvage. And one example is, the issue of whether ships have to carry on board certain documents about their radio and communications fit. How does that work in the context of an MAV? Next slide, please. The third issue is national law issues, and here I'm thinking about how does any given national law define the master or the operation of a vessel. In Australia, in my own country, the Navigation Act defines a master, as you can see there, as the person who has command or charge of a vessel. That can probably be accommodated in terms of MAV when we think about remote command and control. Operate a vessel is to determine or exercise control over the course and direction of the vessel, etc., etc. There's no specific reason that this could not work for MAVs. But then we come to the definition of seafarer, who, and it is seafarers that are the addressees of most of the obligations in the Navigation Act, for example. And you can see there, it says any person who is employed or engaged in works or works in any capacity on board a vessel. So that makes it quite tricky. And then finally, can maritime law enforcement vessels carry out the full suite of authorisations, such as the legal finish, one might say, on the Article 110 right of visit or hot pursuit? There's also an issue around use of force, which we'll come to at the very end, and also issues around vulnerability to cyberjacking. Next slide, please. So thinking about use of vessels, MAV, in drug interdiction, one of the key factors we have to think about is that the Law of the Sea Convention, as we said, does not have a specific definition of vessel, nor does the UN Convention on Transnational Organised Crime, nor the 1988 Vienna Drugs Convention, although the Migrant Smuggling Protocol does have a definition and it reflects the Colreg's definition. And yet vessel is central to these instruments for establishing jurisdiction, the offences committed on board a vessel flying its flag, for creating offences, and also for establishing liability in the boarding and arrest provisions. So there are disconnects here between the lack of a clear and specific definition of the vessel subject to the rule and the rules that are created under these different instruments. Next slide, please. So one of the issues is it a vessel or not? And an interesting question here is, can an MAV be part of the constructive presence nexus? Because as we know, constructive presence requires the ship pursued plus one of its boat or other craft to be engaged. So if there is no, if the vessel itself is not, if the MAV itself is not considered a vessel or a ship, this throws into question whether constructive presence can be usefully employed to go after the mother ship. Operational issues, if there is a MAV carrying a mixture of licit and illicit cargo and we want to divert it to a port to identify the different cargoes, this is very difficult to achieve if we don't even know who the operator is or where the operator is. And then an issue we can talk about perhaps in questions is the destruction of the MAV. Does domestic law allow us, in the absence of criminal process, to condemn the asset to destroy the MAV at sea? Next slide, please. This is also a very interesting issue in MAVs, and that is the extraterritorial jurisdictional matrix. You can see here an MAV which might be apprehended or being an apprehension operation is taking place via a maritime law enforcement MAV. There are different jurisdictional issues, not only the flag of the MAV, if indeed it is flagged and registered as a vessel, but also if it's being controlled from a merchant vessel, the flag of that vessel. If it's owned or directed by a criminal syndicate in yet another state, well, there's jurisdiction in relation to that state. If it's being controlled or directed by foreign nationals from yet other states, then again, there's jurisdictional issues with getting access to those individuals in terms of prosecution. Final slide, please. So there are quite a range of issues that attend the thinking about maritime law enforcement and criminal activity using MAVs. We need to be aware of specific instrument definitions and be clear in terms of whether those definitions provide obligations or rights or exclude MAV from access to those obligations or rights. We need to be very clear about what duly authorised means in terms of having law enforcement powers, and we do need to think about the use of force of delinquent use of force against or destruction of delinquent MAVs. Thank you very much to you all for listening, and thank you, Shanika. Back to you.
Thank you, Rob, for that excellent presentation. Really useful insights into the legal aspects of MAVs, or what is also now referred to as MASS, Maritime Autonomous Surface Ships. The presentation delved onto the question of are MAVs or MASS ships or non-ships, non-vessels, but very interestingly also discussed four pertinent issues. First, looking at it from a legal standpoint, are these ships or non-ships? The regulatory issues, such as what documentation is carrying on the vessel. Three, the navigational control aspects, who's the master? And the legal finish aspect, as you mentioned, the full suite of capabilities. Does these ships or non-ships have the full suite of capabilities? And then looked at it in terms of drug trafficking and how this impacts on maritime drug trafficking. But as we've seen in the aviation domain and UAVs, unmanned aerial vehicles, being used for illegal activity, it is not very long before we are going to see the use of autonomous vessels being used for both legitimate and illegitimate purposes. Rob, in your presentation, you highlighted that MAVs are being used for intelligence gathering, surveillance, reconnaissance. In your opinion, what other roles might MAVs evolve into? Over to you, Rob.
Thanks, Shanika. Yeah, great question. I think that in terms of the maritime law enforcement aspects, I think that we might, in the not too distant future, see MAVs start to be equipped with capabilities where they can cyber interrogate vessels. Perhaps through cyber means, they can tap into a vessel, perhaps through the communications links, and draw out information that would otherwise need to be collected by officers who go on board, check the ship's documents, check its registry documents, check its flag, check its cargo and manifest and those sorts of things. So I think it's a technological question as opposed to whether the law would allow this. That I think is one step we might see in evolution. The second step I think it might be interesting to look at is if these MAVs may in fact ultimately be equipped with cyber capabilities that can hack into a delinquent vessel and stop it, because that's a very easy and less destructive way to stop a vessel, is to hack in, shut down the link, make the vessel stop, take control of the propulsion and the steering mechanisms. So I think that's two possible futures we might see with maritime law enforcement authorised MAVs.
Thank you very much, Rob, for that presentation. I will now pass the floor to Jean-Pierre Spencer, who's a Lieutenant Commander with the U.S. Coast Guard, for the next presentation.
Thank you, sir, for the introduction. And thank you to the Japan Association of Marine Safety for hosting and inviting me to come and participate. Good morning, everyone. My name is Lieutenant Commander Jean-Pierre Spence. I'm an attorney with the Office of Maritime and International Law with the United States Coast Guard. Our office advises on issues revolving around environmental law, regulations and prevention law, maritime law enforcement, of course, and search and rescue, which I'm the primary attorney for SAR, but we get calls and advise on issues for any sort of maritime law enforcement case that comes up that warrants like headquarters attention. Next slide, please. So today I will be providing a general policy overview on some of our developments and issues over the past year. Then I'll have a discussion on our own domestic authorities, which a lot of the same issues as the previous presenter mentioned, we're also struggling with and identify. Then some of the threats that we have identified in this environment, and finally a look at some of our future projects that our research and development center is working on. Next slide, please. Last year, Commander Joel Guido from our office provided a presentation on unmanned and autonomous systems, highlighting the areas of technological innovation and automation in the commercial and public sector, and the potential use by services like the Coast Guard. As technology is continuing to advance and more unmanned craft come online, we're still seeking ways to address this new threat in the environment and looking for ways to enhance our own capabilities. One of the items discussed was the policy implementing human supervised testing of remote controlled and autonomous systems on vessels. While this policy was primarily directed at how to approve commercial testing for remote controlled vessels and autonomous vessels, ourselves, we started to actively incorporate these ideas, these same guidelines in our own long-term decision-making. Next slide. This came in the form of the Unmanned Systems Strategic Plan, which was released by the Coast Guard Deputy Commandant for Operations, Vice Admiral Peter Gaudier, in March of 2023. Captain Remmers was scheduled to attend the next panel. I apologize, he's not able to be here today. He is the expert and helped to author this plan, but I'll do my best to cover that subject. I'll try to keep this presentation primarily on maritime law enforcement. This plan envisions or outlines a vision for how the service will respond to and embrace the emergence of unmanned technology in the maritime domain as a whole. The Coast Guard's vision for the future is not to only establish a regulatory framework, which as we see, there's not a lot of regulations at the moment, to ensure a safe and efficient maritime transportation system, but to also actively defend against nefarious use of the unmanned systems and to use unmanned systems to improve our own service's 11 statutory missions. Next slide, please. Overall, up to this time, most of our efforts have focused on the unmanned aircraft, both in countering the threat they pose and looking for ways to incorporate them into our operations. We continue to see a surge in the use of unmanned aerial systems pretty much everywhere you look. So I'm borrowing some of the images and headlines from my colleagues on the U.S. Border Patrol on the left, highlighting the threats of smuggling and surveillance that they are encountering on a daily basis. On the right is a team of U.S. Coast Guard and local law enforcement, officials in a counter unmanned aircraft deployment in Seattle, Washington. Because of the focus on this area and the existing registration regime with the U.S. Federal Aviation Administration, the authority to conduct operations such as these and the technology in some respects is easier than dealing with surface craft. So now the goal that we are looking at is how to translate lessons learned from this air environment to surface craft. Next slide, please. But aside from raising the threat of unmanned systems in the Unmanned Systems Strategic Plan, it does speak broadly into our future state operations. For example, here's a look at the concept of the systems, where we are trying to incorporate unmanned systems into an operational data ecosystem that can fundamentally transform our operations. This ecosystem would capitalize on data as a strategic asset by connecting manned, unmanned, and fixed sensors, transferring and converting data into information and knowledge, thereby cueing human decision makers and analysts and operators. Next slide, please. But this plan still brings up some practical issues, as the previous speaker mentioned, and as Commander Aquito highlighted last year, the importance first starts with determining whether an unmanned system or craft is considered a vessel. So under both international law and our own domestic law, it's still a broad and vague definition. For example, under our domestic law, watercraft is a vessel if it's used or capable of being used as a means of transportation on water, which alone presents some issues such as transportation of what exactly? Is data alone enough? People, as highlighted, it could be designed for people, but then that brings the manning issue up. Or cargo, how do you define cargo? So another issue is whether that law lines up neatly with the Commander's Handbook on the Law of Naval Operations, which states that the U.S. Navy unmanned systems are sovereign property of the United States and may be designated as a vessel if they are under the command of a commissioned officer and manned by a crew under regular armed force discipline by remote or other means. So the point is that it doesn't quite line up neatly with each other. Sticking with the domestic, though, we do have some case law from the United States Supreme Court that we look to. For example, in Lozman, where the court was looking to, or turned on whether the craft was designed to a practical degree for carrying people or things over water. But the craft at issue in that case was a floating home, which had no rudder or steering mechanisms, was incapable of self-propulsion, and whose rooms looked out upon the world, not through any sort of porthole, but had some very nice French doors, I understand, that were beautiful. So in the end, the court decided that a floating home was not designed to carry people, not a vessel. So we kind of looked at that for what a reasonable person would look at the design of the craft itself. Next slide, please. And I'll just briefly touch on this. Again, most of these issues were raised previously. But if the craft is considered a vessel, do all the same rights and responsibilities attached. Turning back to our own strategic plan. So we recognize that we must establish and enforce a regulatory framework for the safe and lawful use of these systems in the marine transportation system as a whole. Next slide, please. I bring this all up as a topic because these issues directly impact our own Coast Guard authority as currently written. So the United States Coast Guard has been entrusted with a very broad set of authority. However, our primary U.S. statutory authority to conduct maritime law enforcement, 14 U.S.C. 522, relies heavily on our ability to inspect vessels subject to U.S. jurisdiction. Next slide, please. Another example from the prevention and regulation side of the house, again, applies only to a vessel. So this law here is typically used when the vessel is not complying with, you see a lot with environmental regulations or otherwise poses a threat to the port. And we need the vessel to move to protect a sensitive area or waterfront and effect some sort of response. So if the craft is polluting, is not considered a vessel, then this law may not apply, and we might have to figure out something else to address. Next slide, please. Which brings me back to the broader issues. So domestically, the Coast Guard has chartered the Automated and Autonomous Vessel Policy Council, which is working to identify gaps within US laws, regulations, and policies, like the previous two examples, to develop clear and consistent guidance regarding this technology for the maritime industry and our own marine inspectors. And these implications directly involve our law enforcement authority as well. However, at this time, any real world application is going to take a case-by-case analysis. That said, when we're confronting threats such as smuggling, using our statute and the case law as a guide, we're pretty comfortable that a court would find that anything designed to smuggle in cargo, whatever the contraband may be, and has a means of propulsion would be considered a vessel, making it easier for prosecution under US law. Like I kind of alluded to earlier, there's an interesting case when discussing data itself, whether if the craft is collecting data for navigation purposes only, or whether it's designed to transfer that data at some other point in time, whether that could be considered cargo or not. Next slide, please. So assuming all the legal issues and policy decisions are being addressed, there still remains the practical problems of how to combat these threats. Currently, the Coast Guard itself does not possess an organic unmanned surface capability. We do have the experimental vessel on the bottom right, which I'll talk about in a minute. But our Research and Development Center is still working through different programs to try to figure out how we can do it. One of these is the Maritime Uncrewed System technology, utilizing data from a contractor-owned, contractor-operated model, where they operated unmanned surface vehicles or USVs. These were deployed off the Caribbean and Southern California, providing data as a service collected from a variety of sensors, including radar, cameras, and automatic identification systems receivers. This offered an opportunity to enhance our own maritime domain awareness while avoiding prolonged acquisition processes that we see with the government trying to purchase something, and preserving the ability to quickly pivot to new technologies as they emerge. So we're now in the process of evaluating these performances and their potential for future use. The picture on the top left is from one of these systems. The objective of that program was to assess the potential employment options of both surface autonomous vessels and underwater vessels as well to support our mission areas. They also tried the effectiveness of multiple craft at once and incorporating unmanned aerial systems technology as well. On the bottom right, sorry, if you can go back one. The bottom right, again, is our experimental vessel, the 29-foot RDC. This is our effort to better understand the government-owned and operated model. So we purchased a 29-foot metal shark, which is based on our same vessel that we use in most of our stations, so the response boat 2. But this one was configured with autonomy control system that was designed to allow a vessel to be remotely or autonomously controlled. However, the vessel's wheel and throttle remained fully functional, which allowed an operator who was on board to take control of the helm if manual operation was desired. The vessel itself was controlled by a laptop with a particular user interface installed and configured with cameras off the bow, stern, and within the cabin for situational awareness. They completed dozens of navigation, search patterns, collision avoidance, and remote controlled operations. Additionally, to test out the effectiveness of controlling remotely, they were operating this vessel off of Hawaii, some 8,000 kilometers away in New London, Connecticut, using just a cellular service. Next slide, please. So while these systems present opportunities, we recognize that they're already being used by all types of actors in the maritime environment, and we should expect their presence to grow significantly. Whether it's curious citizens using unmanned systems that inadvertently impact the routine operations of government or commercial vessels and coastal facilities, or whether it's narcotics traffickers who have built small homemade unmanned submarines to covertly move drugs illegally across maritime borders. We should expect that these systems will become ubiquitous in the maritime environment. And one of the first priorities is enhancing our maritime domain awareness. So this slide shows another example of a test conducted with Sail Drone. On the bottom right is the online portal. The left window would be reporting the real-time position of each drone, while the right window would list the detections of vessels in a feed. The unit on board used an imagery algorithm and an AI type of system to detect vessels within the images and provided detection alerts typically within 15 to 20 minutes of the image being taken. The drones were also capable of detecting vessels based purely on AIS signals and provided tracking and imagery when it was visible of those targets. Tracking with specific positions was not available for targets detected by imagery alone, as there was no built-in range calculations. However, it was possible to determine the general direction of the vessel traveled based on lines of bearing and detection. And if two drones detected a vessel at the same time, the user could use the intersection of the lines of bearing to determine the approximate position of the vessel. Next slide, please. So with that, the 29 RDC provided valuable insight in its demonstration, and something that we're really looking forward to seeing how we can use that in the future. During that demonstration, we had dozens of partners and our own Coast Guard members, from junior enlisted boat drivers to senior officers, which provided exceptional feedback regarding how to incorporate these into our operations alongside our larger cutters, our other boats, and as a force multiplier. They were able to conduct reconnaissance missions, search and rescue augmentation through these type of search patterns. It's something that we're excited about and something that's addressed in the Unmanned System Strategic Plan. So again, thank you for everyone for listening. I appreciate your attention and looking forward to your questions.
Thank you very much, Lieutenant Commander Jean-Pierre Spence, for that excellent presentation. Lieutenant Commander Spence covered the definition of mass with its vessel and how it is defined within the context of law, and also alluded to both the commercial provided options and also self-developed R&D capabilities in the U.S. Coast Guard. So thank you very much. Next, we have Attorney at Law Toshiyuki Miyoshi to present. Thank you.
Good morning, everyone. I'm very glad to be here today. My name is Toshiyuki Miyoshi, a partner law firm in Japan. In my career, I handled maritime cases such as collision, personal disease injuries, as well as litigation cases. I also conduct research on ship collision cases, legal regulations for autonomous ship, and I have written some papers on these cases. Next, please. Our office is located in Akashi, Japan, less than 1 kilometer away from the Akashi Strait. A large number of collisions occur every year near this Aka Strait. And it is one of the areas in Japan that has the highest number of collisions. Although no ships are visible in this photo, approximately 150,000 ships pass through Aka Strait each year. In addition, serious maritime accidents have occurred in the past, including the sinking of Sekirei Maru on December 8, 1945, resulting in the death of 304 people. The cause of the accident includes strong seasonal winds, high waves, and overcrowding. By the way, my grandfather was also on board at that time, but he's soon back alive. Regulations regarding ships are not unrelated to the past maritime accidents. Rules are almost always reversed after a serious accident or catastrophe. Additionally, many accidents involve human errors. The commercial operation of mass on high sea is about to start, and sufficient legal arrangement and substitution regarding safety are required. Today, I'd like to talk about criminal liability in automated navigation. In particular, I'd like to focus on the topic of collisions. First, I'd like to overview maritime accident in Japan. Second, based on the result of a questionnaire of seafarers conducted in November 2020, I'd like to briefly introduce what seafarers expect and require must to do. Some of the results are published in the Journal of Navigation in 2022. You can find some paper at the ResearchGate if you need. Third, I'd like to consider situation in which criminal liability may arise regarding autonomous navigation. In doing so, I also like to touch upon uncertain laws such as seamanship and the ordinary practice of seamen, which can have an impact on the scope of criminal liability. In conclusion, I think it is necessary to clarify the ordinary practice of seamen and the roles, functions, and responsibilities of seafarers, remote operation center ROC operators, and autonomous navigation system ANS. In addition, common understanding of criminal justice of each country responding to and cooperating when a case occurs is required. Next slide, please. First, I'd like to provide an overview of maritime accident in Japan. In 2023, there were 1,799 ships involved in maritime accident, and 59 people were killed or missing. In addition, the number of maritime accident investigation conducted by the Japan Trans Safety Board (JTSB) in 2022 was 704 ships, of which 193 were collisions. Next, the number of criminal cases. The number of cases sent to public prosecutor for traffic hazard due to negligence was 522, and number of cases referred for causing death or injury due to negligence in the pursuit of social activity was 93. Under Japan criminal justice system, the Japan Coastguard conducts investigations and sends case to the public prosecutor. The public prosecutor will then decide whether to prosecute or not. Next slide, please. Second, I'd like to introduce the survey results. There were 130 respondents, and all of them gave valid answers. 98 of them are currently ship captains or chief officers. Also, 40 of the respondents are non-Japanese ship captains or chief officers. Table shows the range of respondents' age. 43% of respondents were in their 40s. Table 2 shows the year of experience at sea. Over 60% have 8 years or more experience. Next slide, please. Table 3 shows the license type of pilots, and Table 4 shows the license type of the 110 seafarers other than pilots that took part in the questionnaire. The knowledge and experience of the 20 pilots is guaranteed by these licenses, and combined with the fact that 75 of the 110 seafarers have a grade 1 license. Next, please. Is that the vessel mass or not? We asked, due to the emergence of mass, how should the interpretation and the usage change about for reg rule 5? 98 respondents answered. Firstly, this cell need to be identified as mass or not. In addition, if the other vessel is mass, I will try suitable navigation due to the characteristic of mass. See table 5 below for details. This indicates that seafarers are strongly interested in whether mass will maneuver as conventional vessels. Next slide, please. We also asked questions about distinguish mass from other ships. We asked what methods should be taken to help identify mass at sea. See table 6. 125 people, respondents, expect that the transmission of a signal such as from AIS will become obligatory. Also, 89 people, seafarers, requested the installation of shape or lights. Seafarers of conventional vessel want to be able to distinguish mass easily. Next, please. We also asked the following question. Should a kind of seamanship is contrary to the practice of seaman be required for mass? The answer to this question are shown in table 7. The answer to this question, respondents who said seamanship is necessary rose to 74%. Even if mass is considered to be a paddle-driven vessel, the ordinary practice of seaman is required. Next slide, please. As a third issue, I'd like to consider criminal liability. First, I will explain basic concept of criminal liability in Japan. In Japan, if a specific part does not have the necessary strength during the designing or manufacturing stage, and an accident resulting in death or injury, a certain range of personnel at the manufacturer could bear a criminal liability. This was also made clear in the sentence the Supreme Court pronounced in 2012. This case concerns an automobile manufacturer. The hub of truck broke while the truck was in motion, causing the front tire to follow, resulting in an accident that killed and injured pedestrians. The Supreme Court held that a person who was in charge quality assurance at a truck manufacturing company had a duty of care to take necessary measures to improvements such as recalls for vehicles equipped with ship hubs. The logic of Supreme Court is not whether or not part had the necessary physical strength, but rather that despite multiple report malfunctions, the necessary updates and countermeasures were not taken, and as a result, an accident happened. There is a possibility of criminal liability in the event of death or injury. The idea of causing death or injury due to negligence in pursuit of social activity is as known in the slide. The main constituent elements are 1, failure to exercise due care; 2, in the pursuit of social activities; 3, the death or injury of another person; 4, reasonable and probable causation. Next slide, please. Next, I will explain negligence among the constituent elements. Failure to exercise due care is understood as negligence or culpability. It seems that the definition of negligence and culpability in England and Wales and the United States and the care under Japanese criminal law are necessarily the same. In Japan, criminal justice negligence consists of forcibility and duty to avoid consequences. For example, while driving a car at a speed of 50 km high, the driver was distracted and did not pay attention to what was ahead, and was slow to notice pedestrian crossing at the crosswalk. The car collided with the pedestrian, resulting in serious injury that took 3 months to recover. In this case, the driver will be charged with criminal liability. The negligence here is the duty of the driver while driving, foreseeing that there would be a pedestrian walking on the crosswalk, and if the driver could have foreseen it, a collision with the pedestrian could be avoided. If collision occurs despite such a duty, negligence will be affirmed. Seafarers may also be charged with the criminal liability if they are negligent in operating a vessel and this results in death or injury. In fact, a cargo ship third officer was found guilty in the collision between container ship and cargo ship that occurred in the Key Channel on August 8, 2023. Furthermore, the interpretation of the ordinary proxy seaman affects duty of foreseen in Japan criminal justice. In Japan, a gross deviation is not important, but foreseeing the risk is. Next slide, please. When considering the criminal liability, the seamanship and the interpretation of the ordinary proxy seaman are important. What is seamanship? What is the ordinary proxy seaman? One book explains, one view is that the principle underlies all the rules. Another is that it is interstitial in nature, filling gaps left by rules. Another book explains as a specific example, the duty at anchor. Some of the seamanship is determined in Chapter 8 of CCW. However, this does not cover everything, and when navigation rule is not clear, such as navigation between three ships or navigation near the exit or passage, the gaps can be filled in by the ordinary proxy of seaman. Next slide, please. In the previous survey, we asked the following question. What kind of navigation do you expect from Mr. Ray if it is not? There are differing opinions on the answer to this question. Many respondents choose to from the following answers. One, Mr. B will alter course to little bit starboard to avoid Mr. B. After that, Mr. A will proceed straight. Mr. A will be take action with the assumption that on Mr. will reduce her speed for weight to pass Mr. A and Mr. B. Two, based on one, Mr. A will alter course more starboard due to crossing situation between Mr. A and on Mr. However, quite a few people answered that all three vessels should alter their course to starboard. In order to prevent collisions, one interpretation should hold true in a given station. But in a station like one shown in this diagram among three ships, such a common understanding is not necessarily reached. Will any bear criminality in this case? Navigational rule between three ships is not necessarily understood unambiguously. If the own vessel is pleasure boat, the avoidance maneuver for vessel A and vessel B may be different. If the local operator of vessel A thinks that the other vessel will select option 1 and alters her course to little starboard for avoid vessel B, and then proceeds straight ahead, resulting in many casualties, will the operator be charged with criminal liability? Alternatively, if the officer on board vessel A finds out that autonomous navigation system ANS select 1, is the officer obligated to fall back and select 2 and perform give way maneuver? If so, on what basis is it seamanship or is it a safety management manual? In that case, can the officer be charged with criminal liability? In conclusion, I'd like to point out the following points. First, we need to clarify the ordinary proxy seaman. Second, we also need to clarify the roles, functions, and responsibilities of seafarers, local operators, and ANS. To a certain extent, it is expected that they will be described in the STW and SOLAS. Third, we need to promote common understanding of the criminal justice of each country. When cases occur, we need to cooperate to solve it. There may be situations in which it is necessary to clear the jurisdictional issues and cooperate with the investigation. I think these lead to clarification of scope criminal liability. By clarifying these, which in turn minimize risks, MAS can achieve safer navigation with increased reliability. Thank you for your attention.
Thank you very much, Toshiyuki Miyoshi. Yoshi covered areas relating to vessel collision based on his expertise, and also the criminal liability involving mass vessels. The next part of the program is the recorded segment where there were question and answers with Rob McLaughlin. So we'll go to the recorded session, and then thereafter we'll have questions from the floor and also online. Thank you.
I'll open the floor to them. I see Anna Petrig has raised a hand. Anna, do you have a question for Rob?
Thank you very much. I indeed have a question for Rob. First of all, thank you very much for this excellent presentation. You referred to the complicated extraterritorial jurisdictional matrix in case of autonomous vessels used for drug trafficking. And my first question also relates to jurisdiction, but in the scenario where a MAV inflicts harm on other ships, do you think this would qualify as piracy, as the offender is not really on board the offender vessel? And would universal jurisdiction, which applies in case of piracy, be of any help for enforcement action and later for criminal prosecution, given that the pirate is not at sea, but rather acting from on land? And second, from your presentation accrues that there is a lot of legal uncertainty, if not gaps, in transnational criminal law relevant for the suppression of maritime crimes if autonomous ships are used rather than traditional vessels. It seems that a reinterpretation or even a drafting changes are necessary, and the IMO decided to discuss the SUA conventions in its efforts to regulate mass during the regulatory scoping exercise, but decided not to continue the discussion despite some gaps and uncertainties. So what about drug trafficking and other crimes? What role do you see for international organizations in tackling these issues? And do you think, is there any prospect that a discussion will take place any soon, given the imminence of the issue? Thank you very much.
Thank you, Anna, and it's a great pleasure to have questions from such an eminent expert. Anna, in your first question, thinking about piracy, I do think that an MAS or an MASS or an MAV can be a pirate vessel in accordance with the definition in Article 101 of the Law of the Sea Convention. I do think it can fulfill all of those aspects. But the interesting point you made about the operators, can the operators who might be ashore, for example, be covered by that? And I think, yes, I think Article 101, particularly sub-Article C, for example, captures operators who are remote from the actual vessel, the pirate vessel. And even if we didn't capture them as operator or such, we would capture them, I think, as, have jurisdictional reach in terms of them being facilitators, organisers, something along those lines. But the more interesting issue, I think, is, as you pointed out, universal jurisdiction, because even though we might have universal jurisdiction over the MAV, the pirate MAV itself at sea, that doesn't extend to universal jurisdiction to just go into the territory of another state and seize the operator as a pirate in accordance with, as defined under Article 101. So yes, that does throw up certain complications, I think, in terms of the full suite of jurisdiction that's available in relation to piracy. Your second question, I think that, I think it's a two-step process. I think you're absolutely right that the IMO and other organisations need to assess those lacuna and gaps. They need to determine whether there are drafting changes required. For example, we talked briefly about, the idea that vessels must carry on board documents relating to their, to their communications outfit and the qualifications of the seafarers on board. Well, traditionally that's paper documents, of course, but could that just be some sort of, cyber communication that then transmits those documents and fulfills that? Or do we have to actually, engineer a drafting change to make that workable in terms of MASS or MAV? The other question is about implementation, and I do think that other organisations, UNODC being one, of course, can look at how the existing mechanisms, I'm thinking, for example, about the existing mechanisms under the Vienna Convention, Drugs Convention, Article 17 in particular, in relation to illicit traffic of drugs by sea. There are existing processes there which are sort of technology agnostic, and there's no reason that they could not be employed in relation to MAVs as well. So it just takes a bit of creativity, I think. But I think that existing mechanisms should be okay to tackle this, so long as the preliminary question is addressed, and that is whether these vessels in any given jurisdictional matrix are, whether these MAVs in any jurisdictional matrix are actually considered to be vessels and then subject to the obligations and the rights of such vessels and subject to the jurisdiction applicable to vessels. Thank you. They're great questions.
Thank you, Rob. The next question is from Kentaro Furuya. Furuyago Kentaro. Over to you.
Oh, well, thank you very much, Rob, for your insightful presentation. Can you hear me, by the way?
Okay, thank you.
Next to my building is a helipad, and the helicopter is now leaving, so maybe it's noisy. I have two questions to you. The first is the status of the MAVs. Do you consider the MAV used for smuggling as a ship or device? If you think it is a ship, it is on the high seas under the exclusive jurisdiction of the flag state. So we need to seek the right to exercise jurisdiction or intervene to the MAVs. If it is a device, it may be just a property at sea. So there may be another way to find out to intervene, smuggling of drugs by MAVs. The second question is last slide. I have seen the destruction of a MAV. That sounds like an easy way to dispose of possible unseaworthy objects at sea. But at the same time, it seems highly problematic since MAV would be a part of evidence necessary for criminal investigation and prosecution. Is there any, the laws or regulation under domestic law of Australia to allow the authority to destruct, those MAVs found for smuggling operations on sea, or what is the legal basis for the destruction of MAVs? That's my question. Thank you very much.
Thank you, Dr. Kentaro. Forgive me for just writing a couple of notes there. Again, two wonderful questions. As to the first, you are quite right. If an MAV is categorized as a ship or a vessel on the high seas, then and has a flag state and registration and all of that checks out, then you are quite right. It has the same rights as a crewed vessel, and we'd need flag state consent to do counter drugs enforcement. We would still be able to use Article 110, the right of visit, to if we found one of those situations like Anna was just talking about in terms of piracy. And of course, once it entered our contiguous zone and in our territorial sea and internal waters, then we have other bases of jurisdiction where we don't need flag state consent. So you're quite right. And there is, I think it's much less clearly understood what is able to be done to mere property that is not a vessel at sea, and that does raise some different issues. However, I would say that with MAVs, there is the potential, I guess, that they might more immediately be reasonably suspected of being vessels without nationality. If they're small, like some of these narco submarines, they're not displaying any indicia of nationality, no flag, etc. They're probably not responding to warnings if we can actually work out how to do that. So we might actually be able to board them initially using Article 110 with a reasonable to check their nationality. Then, of course, if we discovered, a massive haul of drugs on board, it then becomes an issue of national law as to whether those drugs could be seized even in that situation. Your second question about destruction of MAV at sea, yes, agree. I guess the two things I would say there are, one, law enforcement agencies might make a conscious decision, especially given the extraterritorial jurisdictional complications with, actually getting hold of the operators, extradition processes. You might not even have an extradition agreement with the location where or the nationality of the operator or the location where they're controlling the vessel from. So a law enforcement agency might decide to just carry out disruption. And in a way, if you just sink the vessel with its cargo, there might be many happy fish, but who's really going to complain? Because, it's a drug it's a drug trafficking vessel, it's unlikely someone's going to come to your national courts and say, I need compensation for the destruction of my property. It's possible, but unlikely. So there is that disrupt rather than prosecute option, I think, in this situation, particularly where there's no people on board and it's just a bad cargo and a bad vessel, and we just can't. We're not likely to get hold of the perpetrators for an actual prosecution process. Your point about evidence, of course, is very important. I guess I'd think in terms of, and again, Anna may have some comments here as well, but in the Somali or the counter-piracy experience, quite often the skiffs were destroyed. Yes, there was other evidence that could be taken. What was on board, obviously the people, the pirates themselves, weapons, photographs, all of that sort of could be taken, and that would still prove sufficient evidence to ground a prosecution. Really good questions. Thank you.
Thank you, Rob. We got 1 to 2 minutes more. Could I ask Seta Makoto to ask a question, and then that would be the final question. Over to you, Seta.
Thank you very much, Professor McLaughlin. So actually, I have 2 questions, and one is very close to the last question by Professor Furia. So yeah, according to the case laws of the international court and tribunals and other some kind of decision since the I'm Alone case to the Saiga case and the Virginia G case, the use of firearms should be limited to the as some kind of last resort and must be the some accordance with the principle of reasonableness. And according to that kind of principle, so probably the Coast Guard agency face some kind of a difficulty to use firearms against in any devices. But in the case of the autonomous vessel because there are no personnel, so do you think that some kind of a different standard should be applied? So is this your understanding? So that's what I want to confirm. This is the first question. And the second one is that the immunity issues. So because US looks to claim that so their Navy UUV, so unmanned underwater vehicle, is also should enjoy. According to the UNCLOS, the warship must be distinguishable by the external mark. And I'm a little bit wondering, so to what extent the UUV used by the US Navy vessel is distinguishable as a kind of a property of the US Navy? So, and is it common for, in this case of the UUVs to make, so distinguish is easy to have? So that is my second question.
Again, some wonderful questions, Seta-san. The first question on the use of force, yes, that is my view. It's probably quite contentious, but I do think that the test of reasonableness, when you're talking about a delinquent vessel involved in an illicit activity where there is no threat to life at all, I do think the test of reasonableness in terms of the use of force to stop the vessel and in fact even to destroy the vessel, if that is the administrative decision made, is different to the test we apply, of course, when there are humans on board. There's no law I can cite for that, but I think that, you know, the trajectory, as you mentioned, from I'm Alone through Red Crusader, through Saiga, through Virginia G, etc., the trajectory of what is reasonable is not linear. And so I think there is room for different interpretations of what is reasonable in this law enforcement use of force scenario, depending on the nature of the vessel and the presence of human life or not. Your second question about sovereign immunity, I think that's a really interesting one. Yes, UUVs, underwater, uncrewed underwater vessels are clearly can be claimed or are being claimed as sovereign immune vessels by the US, by Australia, by the UK, by many countries. And your question is really about, you know, warships displaying the external marks. I think in this case, you would think about a UUV in the same way you think about a submarine. So if a submarine is beyond the territorial sea, it can be dived, and really, you know, unless you are very good at tracking submarines, you're not even going to know it's there. So the issue about external marks and identification isn't practically an issue because it's entitled to be dived and unknown, its presence unknown. If a UUV comes into the territorial sea, I think the same rule would apply, in that its external mark would be, as is the case under the Law of Sea Convention for a submarine, that is, it must surface and it must show its flag. And I think that the same requirement would exist for a UUV And indeed, if it didn't comply, then it would be in breach of innocent passage.
Thank you,
Thank you
Rob.
very much.
I think we are out of time. Appreciate the time from the audience as well as the panelists. And Rob, thank you very much for your presentation and
Pleasure.
and answering all the questions. This recording will end now. Thank you very much, everybody.
Thank you.
Thank you for your viewing of the recording that we did a few days ago. Now we have an opportunity to ask questions from the panelists in person and also online. We have one online question, but I will open the floor to the people here. If there are any questions. Two questions, one gentleman at the back there.
Good morning, everyone. It's Timo Schubert. We work with JAMS to provide EU policy monitoring services. A question that was already on my mind yesterday, and I didn't ask it. I spoke to some people in the room. I think what's very interesting to see when we talk about mass and the unmanned vehicles is the great level of similarity to some of the challenges we see in the aviation community. I think at Coast Guard, you gladly mentioned UAVs there as well. If you have Coast Guard functions and you have the pleasure of dealing both on the marine side and also on the aviation side, I think a lot can be learned from some of these challenges that both modes of transportation have. If you look at the work of the European Union, at the European Aviation Safety Agency, for example, there's a lot of rulemaking ongoing on trying to get fair and safe access to airspace done, similarly to how you are trying to achieve fair and safe access to the marine space. So my question is there already a dialogue open and ongoing between the maritime and the aviation community to look at common interests and solutions for some of these problems? Electronic conspicuity is the name of the game in many extents. And if not, I would dare recommend that such dialogue is launched immediately.
Hello? Okay, test. Thank you for the question. And yes, so like you said, these are similar environments. The challenges have been really the same. The ease of use of getting these types of devices for anyone have really present all these same unique challenges, like I said. But yes, there is dialogue ongoing, modeling after our unmanned like aircraft counter policies and regulations that we've had. So we're currently working on some sort of plan using these lessons learned for the future. So, thank you.
Thank you. Thank you for great presentations. Well, I'm Takashi Hongo. I have a question about extraterritorial jurisdiction, which is already somehow covered by the recorded session. Well, if you think about the case, for example, accident what happens in the territorial water of the country A, like US, and but the vessel, the mass is operated remotely, for example, from Japan. Well, it is quite hard for the Coast Guard of the state US to conduct investigation. Well, in case of traditional vessel, well, at least the master chief officer or other crew must be on board, so the Coast Guard can access those people, or they can collect the information directly. But when it comes to mass, well, there's no one and probably no record on the vessel, and it is operated by remotely from other jurisdiction, and it's quite difficult for the Coast Guard of state A to exercise its jurisdiction. And so my question is, well, for example, the US Coast Guard is thinking, well, is there any discussion in the US Coast Guard about how well, you can approach this issue, but for example, are you thinking about any way to, well, exercise the jurisdiction out of your own territory?
Thank you for the question. Yes, they are considering that as well. I mentioned briefly, and Commander Quito last year talked about the human supervised testing regulations, and that's when we really started to delve into what expectations do we have on industry and the public as they're like even starting with testing. We had, vessels that, we started off with very small, 1 to 2 foot long. Now we're seeing, SpaceX and other large commercial entities that have, 75 to 80 foot long vessels out there. So it's definitely something that we are looking into. And the council that was the Coast Guard chartered, which I'm sorry, skips my brain at the moment, but they are looking at gaps in the regulations at the moment and trying to figure out how exactly we would expect industry to comply with that. Thank you.
Any other questions from the floor? Yes, one more question from the floor.
Good morning or good evening, whichever it is. Have we lost our Australian speaker? Is he not online at all?
Unfortunately, he's not online. He recorded his presentation.
I mean, I'm not quite sure where this term MAVs come from. It's not one that is in common use. And it immediately raises questions about what the V word means, whether it's a vessel or a vehicle, and whether it's on or below the waves and so on and so on. As the chairman of the UK MAS Reg Group, I would caution against the invention of new terms just at a time when I thought things were leveling out. I mean, the other thing is that, of course, there's been very little reference in this morning's panel to SOLAS. And what we do now know is that the code, which is being worked up in IMO, albeit voluntary, and then 3 years later, mandatory is the expectation, is a subordinate, as we heard yesterday, to SOLAS and not Colregs. And of course, it's the Colregs-SOLAS tension that has existed, which a lot of us have had to deal with in the previous years. I just ask, why we're hooking things on one particular term. And I'm very well familiar with this, the US version. I deal with American lawyers and so on. And I'd appreciate a slightly rounder view on this. You homed in as you need to on one particular aspect of it. But where do you see this slightly broader picture? But at the same time, finding down for those of us who are out here in numpty land to understand what people are actually talking about when they talk about them.
Thank you. That's a good question. And I understand the the frustration with the various terms and how they come about. Like I showed with our recent one, we settled on unmanned systems. But even in that policy, it talks about, vehicles. And so I understand completely. With that being said, I know that other colleagues in our office in the maritime and international law on the prevention side, they are working closely with the IMO to ensure that any regulations that we develop are all complying with their own regulations, that everyone's lining up for easier passage in the future. I don't have a good answer on the Colregs versus SOLAS one, though, unfortunately, but I know that it is a topic of discussion. So thank you.
Well, thank you for your presentation. I'm Hernando Alfrade from the Spanish Maritime Administration. First, just support that James Sponsor said about the question of subordination to SOLAS, and also pointed out also the issue that UNCLOS doesn't include a ship definition. And for sure, it's a pity that this professor from Australia is not online. But Lieutenant Commander, this is a question for you about the jurisdiction of the remote operation center. what it happens, not in the case of an unknown underwater vehicle or a USV or whatever, but a merchant vessel, if this remote operation center is not located at the territory of the flag state. That poses a new threat or a new challenge and how to enforce the situation as it's not under the jurisdiction of the flag state. What do you think about the issue? Thank you very much.
Yes, that is an issue. No, and I don't have a good answer for it this time, but it's something, again, that you're right. If this vessel, we'll just call it an unmanned vessel, is operating under flag state jurisdiction, but the remote operator is located in a third country, how do we even begin to address that issue? I do not have a good answer for that. So, but thank you for the question.
Any further questions from the floor? Yep, one over here.
Thank you. My name is Motono Tsuchiya. As I introduced myself yesterday, I'm working for Liability and Registry. We have to be careful about the definition of mass because mass in IMO's term includes manned, highly automated vessel as well. But I think what we are talking about this morning is unmanned mass. And when it comes to criminal criminal prosecution, in my recollection, as ex-Coastguard officer of Japanese Coastguard, it is regulated by penal code to justify or to prosecute any wrongdoer or those in case of collision. Is those law or national regulation define a ship, and if that definition of the ship include unmanned ship, i.e., as the previous speaker raised the question, whether unmanned ship can be qualified as a ship in the law, national law that relevant to the prosecution of the wrongdoer. Thank you. I hope this question is clear, but if not, I will further explain.
Can I speak in Japanese?
In the Japanese law, the no punishment result law exists. So when it comes to vessels, they're not defined. So in that sense, it's not easy to apply that law, whether it's floating or whether it's carrying any cargo, or if it's moving, that would be a vessel. So if you're meeting all those three requirements, perhaps that can be a vessel. Whether that's manned or unmanned, that's not part of the scope of definition in the Japanese law.
And I would just build on, similar with US law, whether or not a craft is a vessel, we're looking to its design overall. So we have the one statute that defines it, that then would apply to the other statutes. If it's capable of being used as a means of transportation for people or cargo. The capability is really what we're looking for, not necessarily whether there is someone on board or not. Thank you.
Are there any further questions on the floor? One more.
Thank you very much. Good day to everyone. My name is Mauricio Cruz from. My name is Mauricio Cruz from Mexican Maritime Administration. My question is for Toshiyuki-san regarding the liability. I have the impression that in Japan, they have a strong insurance industry. And what is the approach of that insurance industry regarding the autonomous vessels?
I speak in Japanese.
Yes.
Sorry.
In terms of the insurance, it's not a criminal responsibility, but it's more of a civil liability. If some accidents are foreseen, then you have to have an insurance, and so that would be within the civil code. That would be separated from the criminal liability. That's my understanding.
Any further questions from the floor? I'll take a question that has come online. Question is Attorney Miyoshi referred to the Japanese national law regarding endangering traffic through negligence. I have a question for Lieutenant Commander Jean-Pierre Spence regarding the US law on criminal negligence of collision at sea. Specifically, I'm wondering if there are any provisions in the law that apply in cases where there is no fatality or injury.
Thank you. Yes, and short answer is yes. So there are laws that require the operation of a vessel to take due regard for safety. So if there's, and I believe the language of the statute, I apologize, I don't get quite correct, but if someone operates a vessel carelessness or recklessness, so that does not necessarily require injury or harm. It's more of a reasonable standard that would be applied. So I could envision actions taken that were just so egregious that endangered everyone around them that they could be held liable. Thank you.
Thank you. And that question was from Kentaro Furuya. There are no further questions online. Just one question from me, following up on the question regarding the comparability between UAVs and USVs. The environment is somewhat different. So in the aviation space, you have what are called FIRs, flight information regions, and you have an air traffic control system where altitudes are given for different vessels. So you've got to inform that you're entering the FIR, get permission, enter it. In the maritime space, you have your territorial sea, your contiguous zone, your exclusive economic zone, and the high seas. So there's innocent passage. There is no control mechanism that you have to get permission to enter any of these zones. So there's a difference in the operating environment. Any comments on that?
Absolutely. And we found with the aircraft working closely with the U.S. Federal Aviation Administration, they already have regulations set up. They were quick on the ball there, and we were able to build on that. Absent that sort of regulatory framework for these unmanned systems or unmanned vessels, whatever you would like to call them, that's going to be one of the big hurdles that we'll have to initially address and lay that foundation in order to move forward. Thank you.
Just one further question from the floor.
If I can pick up on this point of corroboration, as it were, or certainly interchange with the aviation and the maritime, it goes much further than that. You know, it goes into the roads and so on and so on. And here in the UK, we're on the maritime side, there's a developing relationship with the Civil Aviation Authority. And it's not so much what can we use, it's what do we not need to use that is really important, because it's wrong to make a working assumption that you just sort of take all the experience of the aviation world and dump it on the maritime. Doesn't work that way. But there are certain things which have been found to be necessary to consider. And I think that's the process that's going on. It's less of how much can we shunt across from the aviation world, or I would include in this road and rail, and other sectors that you don't immediately think about. You know, the agricultural sector, the medical sectors. You know, all these people are using autonomous systems in some degree or another, and they found by experience what works and what doesn't work. And what we've got to do in the maritime world is say, very good point. You know, you can crash through bits of sea and you don't actually notice that you're going into the territorial waters or whatever it is. You should do. But you don't actually have to do anything until you get to a BTS point and so on and so on. We all know the rules, those of us who go down to sea in ships. But I just wanted to, you know, throw into the mix that we mustn't go overboard here by saying that, you know, if it works for air, it works for maritime. Wrong. But there's an awful lot more that doesn't work necessarily than does. But we should all be talking. And indeed are.
No, I agree 100%. So they are very unique. And there is, I like your point about rail, agriculture. There's a lot of other practices out here that we can learn from. So I think the key moving forward is going to be reaching out. So, and developing more of these organizations or like our charter groups that we look for to engage with these different sectors. Thank you for the comment.
Thank you very much. I think that brings to an end panel discussion. There aren't any more questions. Thank you. Back to you.